Welcome back to the Cordell Cordell and Men's Divorce video and podcast. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. And as we do each day, including on Thursdays live, we bring you the latest information from our attorneys around the country. And today I'm joined by Maura Boogay in Philadelphia, Pennsylvania. Maura, welcome.
Thank you, Scott. Good morning.
Good morning. So also before we get started and talk about the topics that affect guys and as a result of COVID, disclaimer, I always do this, and that is it's not legal advice. I don't want you to take it as such. I'm only licensed in Missouri, Illinois, and Georgia, and my guest is from Pennsylvania. Again, this is more for educational and talking points for you to seek counsel. Obviously, if you need a consultation, we're available at 866-DADS-LAW or online at CordellCordell.com. We can do virtual and telephonic conversations and consultations with you. Seek us out. We're here to help. And hopefully this podcast will give you the tools to try to get those questions answered. So go ahead and seek an attorney or we're available. But let's get right into it. So Maura, really, one of the things that over the last number of weeks we've been talking about from around the country is really finding out what's the status of courts. And as a result, some cities and some states, courts are, we use this word closed. And when I think of the word closed, I always relate it to a restaurant. If it's closed, it means the door's locked and you can't do anything. There's no one working. So that word brings with it connotations of you can't do a thing, not filing. We're going to talk a little bit about it, but start everyone who's listening off with what's happening in Philadelphia and the surrounding counties, as well as the state generally when it comes to the court system. What can happen, what can't happen, what's going on?
Mm-hmm. So Pennsylvania is a little tricky because every county is different and has their own local rules and procedures. So what we're finding is our state Supreme Court we have a web page where we can go and click on any county's most recent order with regards to their procedures. Some counties are allowing filings, although when you talk to the staff one-on-one, they're being honest and saying not much is happening with those filings once they're received. And then other counties are trying to implement as many remote procedures as possible on hearings, not trials. Trials are certainly stayed. Right now, our courts are closed through May 31st at least. But again, each county can extend. Yesterday, one of our local counties, not Philadelphia itself, but one of the counties right outside, extended to mid-June. So with that, they're extending filing deadlines and those kinds of requirements. But you have to really look at your specific county's procedure to see, can I file something? Will it actually be processed? And can I have a conference? The most recent development is that to have a conference in Chester, Delaware County, and Montgomery County are three pretty big counties where we are around surrounding Philadelphia. Counsel or both parties have to agree to have a conference on substantive issues. So if one side is benefiting from inaction, they get to just say, no, I don't agree, because I suppose the policy is making sure everybody has the electronic means or ability to participate remotely. So later it's not an appealable issue. It's my guess. Maybe,
yeah.
So it's still limited how you can get into the courts in most of our counties.
It's a difficult thing because, every Thursday we get the new and updated unemployment numbers, and now we're over 30 million unemployed. And, it's a staggering statistic because, you've got probably figure 15 million guys, half of those, so about, let's just call it 8 million divorced guys right now who likely have an issue paying child support or spousal support. And they're trying to figure out, what do I do? How do I make these payments? When am I going to be in trouble? And they don't know where to turn because all they hear is courts closed, nothing can happen. And so that really leads into the conversation of, we've talked about 2 weeks ago, one of the mistakes is doing nothing. Mm-hmm. And, I've talked to a couple of attorneys around the country. In New York, they weren't taking any e-filing. And then pockets in Florida were taking no e-filing. So you couldn't even put any in notice. And one of the important things and why I think today's topic and talking about strategies when your courts perhaps aren't taking filings is paying attention to, this notion of retroactivity. And we use that word really loosely because it's a legalistic word. But what it means is, and I want you to comment before we get into the subject, is for guys to take action, if you feel like, and your attorney says, look, you're entitled to likely a reduction based upon this unemployment and your potential employment opportunities, that child support amount continues to accrue until so typically in Missouri, for example, I can give the judge the power to make the new child support order retroactive back to the date of filing, meaning that if I owe $500 now and ultimately says you owe $100, I get a $400 per month credit all the way to the date I filed. So what is Pennsylvania's law as it relates to retroactivity for anything, support or maintenance?
Luckily, it's the same. So we
Okay.
can go data filing under these circumstances. There are some rare circumstances where you can go beyond that, but in this instance, it would be data filing. And so the key is, and we're talking to all of our clients early on, if you experience reduction in income or unemployment,
Mm-hmm.
filing as soon as possible is what you need to do. And luckily for us, our local domestic relations, which is the department within the court that handles support, is saying, file it, you'll preserve, mail it in, or we fortunately do have a statewide e-filing system. It's imperfect because it's statewide, it's not county specific, but it is preserving effective date. So certainly if there's an issue, that's the key. Send it in, hope that it gets time stamped, whether you get it back or not.
Right.
Try to use the statewide system and preserve effective date, right?
Right. We had an attorney, I believe in New York, mail or overnight their pleadings because the courts were technically closed. And the question becomes, well, it was returned to them. Courts just didn't accept it, didn't file it. So is a strategy, and I've heard this, a strategy, a good one, to take a pleading for child support or whatever it is your relief is seeking and mail it or overnight it or to opposing party and or their attorney to kind of put them on notice? And if so, what's the advantage of that?
Mm-hmm. Well, I think certainly with support, be on notice. I'm going to ask for retroactivity for a modification. But another example would be in one of my cases, I had an opposing party. Well, let me back up. Philadelphia is a very overcrowded court system. And so it's not uncommon right now if I asked for a divorce master's hearing, which is our lower level initial hearing, that I'm not going to get it until the winter. Literally no exaggeration. And so I have, these clients that are paying spousal support. The other side's in my particular example, I have opposing party doesn't have an attorney and she lives in the marital residence and she wants to keep it. My client's fine with that, but she'd need to refinance. She knows she's not going to be able to. So this is the perfect opportunity for her to, I don't want to say squat, but the court system's not available to me. And so I'm just going to kind of hang on and I can stay here. And I know we're not going to get a hearing if the courts don't reopen until the end of, say May or June. Well, I'm looking at next spring for an initial hearing. And then I have appeal process after that within the Philly court. So what I said to my client is, why don't we, she's pro se, she's not taking this seriously. Why don't we prepare a petition for special relief? Tell her we're going to ask for attorney's fees to compensate for the difference with our client not being able, he's renting. Let me back up. He's renting. And our argument is, well, he's throwing away money on rent payments that aren't invested. He should be able to buy a home. He can't. He's on this mortgage where now he's not able to get a second mortgage, and he'd otherwise be able to invest and get some return if he could purchase his own home. So she's there and she's not taking it seriously. So we sent her a petition where we said we'd ask for attorney's fees. We'd ask for a credit and equitable distribution for her sort of not moving forward and at least seeing if she could pre-qualify to refinance. And within a week, we got a property settlement agreement. We had an agreed upon period where she's going to try to refinance. And if she can't, because otherwise she was just going to stick her head in the sand. So it was very successful. And I've done the same thing with discovery. If the other side's not giving anything, prepare your motion to compel, send it and say, I'm sending this in, whether it's scheduled or not, it will be at some point. And here you need to, they're still not going to necessarily comply within state rules timeframe, which in Pennsylvania is 30 days, but it is getting a little traction. It just has more teeth than a letter, for sure.
Yeah, right. I have to believe, and I think it was Rosario in our San Diego office, same thing, thinking she had a conversation with a judge kind of off the record that said, look, the courts, we've kind of talked about this. If you can't get filed, we're going to look at service, informal, non-filed petitions as kind of the line of demarcation for retroactivity. Mm-hmm. Meaning that if a guy serves mom with an unfiled petition, judge is going to give it great weight to go, because they're courts of equity, to go back to that date of putting the party on notice who then refuses to engage in a conversation. And don't you think that that's probably something that, makes sense to you?
I think that most judges, because we're in a court of equity, they're going to consider when was this filed, what efforts did the attorney or the party make while the court shutdown was in place. So certainly sending to the other side a petition, here's our issue, here's our proposed request for relief from the court. Number one, it shows good faith attempts to settle, which obviously all of our judges appreciate. And it does show this is when you took a very serious effort to rectify this problem. We're going to go back in whatever relief that we provide or grant you to that date at very least. I think it's important to show all the judges want to see attempts to resolve these issues out of court. They're aware that there's going to be a lot of backlog when they reopen. So I think that it goes a long way to them to see that counsel took serious efforts to try to resolve something during the shutdown.
Yeah, I agree. I mean, I think not only that, it's again about guys taking action when they can and not sitting around waiting and then, lollygagging and saying, well, COVID. And I think this is hard to get this message out, but I think it does show proactivity. I think you're 100% right.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
So one of the other issues is really, what do you do with childcare costs during COVID-19? And, a lot of facilities are either shut down or, they're varying their terms. What do they need to be considering out there when it comes to childcare?
So I think for obligor, for the person who's paying, some daycares we're finding are still charging or were still charging for part of the shutdown. And some support receivers were saying, well, I'm still paying, so you still have to pay me. Obviously, if you don't have the best relationship with opposing side in terms of trust, contact the childcare provider directly, get an understanding of their policy to see if they are in fact charging or were charging for part of the COVID shutdown. You're going to want to be reasonable with working with opposing parties. So if the daycare provider was charging legitimately during part of the shutdown, try to agree upon, okay, we're going to still split this cost. But at some point, I've had some clients say, enough is enough. They're still charging, but my child has been out for, 8 weeks now or 7 weeks. So I think that everyone needs to operate with a little bit of common sense. I, for example, had a client where the child goes to an at-home daycare and this woman, doesn't have really overhead. And she's saying, oh, I'm still charging $600 every 2 weeks. And my client decided she wanted people to still pay, obviously. And my client said, no, I'm not going to pay because you don't really have overhead or operating expenses. My child's not there. There's no service. And I told him, I don't want to use a double negative, but I don't disagree. But put aside some money. Don't go spending it all like now this expense is alleviated. We have no idea what the court's going to do with this. So I said, just put the money aside and let's be ready for whatever the court decides. But you really have to get the information from the childcare provider and you have to work with the other side and you try to defray those costs. If they have to get supplemental, if the other side has to get supplemental childcare now because the daycare facility or whatever childcare facility is no longer in operation, try to defray by saying, I'm available, and say that in writing. You can always say, I offered my services at no cost. I'm the other parent. I wanted to help defray those costs.
Yeah. I think, this pandemic presents so many unique challenges and questions and issues that there's really no clear-cut answer anymore, especially with childcare. And maybe it's a solution of, hey, I get it. You have to reserve your spot, but you're not to pay the full amount. Maybe guys think about having a conversation of, okay, negotiating with both your spouse or your ex-spouse and saying, okay, let's pay half the amount just to keep the spot open. As you suggest, you don't have the overhead, you're not open, child's not there, all kinds of unique opportunities. But I just foresee as we get into the court system at some point, I guess there's, somebody's going to have to file something at some point if you're the payee or the payee. Don't you think at some point, are there options for guys that they file something later on once court system's back open?
I mean, I think so. In other words, if they're out of luck because they've paid this whole time, not out of luck, but they're out all of this money, I think there's an opportunity to apply a credit, to their child support account. And the courts, any local bar association meeting right now is saying, they're admitting, when the court comes into those meetings, they're saying this is uncharted territory. We don't exactly know how we're going to rule on these issues yet. So we're all a little bit in the dark. You just have to act with as much common sense as possible and sort of brace yourself for a result either way when the court does reopen.
And it does mean, I think, if I'm a judge, I'm going to be encouraging the attorneys more than ever when they're facing issues that judges have never faced before, work it out, find a resolution here, because I don't want to have to issue something that is unique, a case of first impression, and then start angering everyone, because that's what's going to happen. You control your own destiny to some extent if you have a reasonable attorney on the other side, a reasonable party. Be creative. And I think kind of wrapping up what we've been talking about, one of the things I suggested was a conversation with your attorney to reestablish your goals, rethink them, because especially during COVID, maybe your goals were a little too aggressive now. They weren't then before COVID, but they are now, because not only are we facing unique circumstances, but we're facing tenfold delays. You may not be heard, as you suggest, until winter. Now we're probably looking at the next summer. There are some jurisdictions like St. Louis County, the typical average is 8 to 12 months. We're probably looking at 16 to 24 now, which takes us back to when I first started practicing in the 90s, early 90s, where 2+ years was not unusual, and it was crazy. So I think you point out, a conversation with your attorney, thinking about goals, talking about strategy, considering filing, putting people on notice, writing, negotiating, it's hugely important for guys, I think. So
it is.
That's great advice, Maura, and I thank you for joining us today. The guys really just have so many questions. They don't have answers, and they can't find it on the internet because these are uncharted territories and times. So I appreciate your time today.
Thanks for letting me join.
Well, as usual, we'll continue to bring you the latest information. Continue to tune into our daily podcast. Check us out at CordellCordell.com and tune into our virtual town hall meeting on Thursdays, where we join a panelist of Cordell Cordell attorneys to answer your questions live. Until next time, have a great week.